And Bob, now you're adding to the pile. How does that work ego-wise as well? You bring in another member of the team, and things can either go really well or go south.
Yeah, and most of the time they don't go well. And here's the thing, as you indicated, these lawyers did a great job. And so there's an old axiom in the law a judge told me when I tried my first murder case. When you stand well, stand still. In other words, don't mess with something that is working. Now, there are egos that are at play. When I have had cases where I've had to work with co-counsel, you have to start working right from the beginning as to who's the shot caller. And trial lawyers, by definition, are very egotistical, type A personalities. They like to be in control. And trying a case is not like 1 + 1 = 2. It's nuanced, it's artistic, and people will have different points of view about how to do things. Now, I can tell you personally, when I've tried cases with other lawyers, if you don't have this kind of structure set up from the beginning, then you are destined to have people starting to argue and kibitz even about when you ask a question, how you ask a question, should you ask a question. So look, just because you add on a high quote unquote celebrity lawyer, whatever that means, doesn't mean you're going to get a better result. I would stick with what I had because these guys did a great job, and all you could do from this point forward is make that worse. Let me just start with being a homicide prosecutor. The fact that your main detective credibility is going to be beaten up like this is something that's a stake through the heart. Now, as to the cell phone records, I mean, I have to ask again, as a person who's investigated these cases, to the prosecution, where have you been? Where are you? Why are you asking for these records after an entire trial has occurred? Now, supposedly the argument is that the father went on TV and made statements that contradicted statements that the defendant made. So let's go back to law school a little bit here. A statement by a defendant is hearsay, but it's an exception to the hearsay requirement, so therefore it's admissible. What prosecutors are saying here is that the father's cell phone records and the mother's cell phone records bear on the credibility statements that the defendant gave to the police, including the fact that she indicated that she first spoke to her father, I believe it was, when she was at the hospital at like 7 o'clock in the morning, when phone records are going to show that it was at 6:30-ish in the morning that she had a 3-minute and 51-second conversation. With regard to the mother's cell phone records, it's a little bit more nebulous. I looked at the motion paperwork. You know, it's very vanilla, very antiseptic, but it basically indicates we want the mother's cell phone records from a month before the incident happened, which I find to be extraordinary. In the event the father testifies for the prosecution, which prosecutors say they're going to call him now to show those contradictions, and should he say something that contradicts the story, that they should be able to use the mother's phone records, I think that's a little bit weaker of a situation. And why they're doing it a month before the incident happened, I think they're going to have to go a long way in court. But Ted, unfortunately, their paperwork is very sparse on facts and reasons.